Welcome to what is the fifth of we're calling this our Winter 2021 webinar series. It feels a lot more like spring today. Had we done it 10 days ago, it would have definitely been winter, but it feels like spring, so that's a positive thing. So far a very positive week, and hopefully after this evening, you'll all have a very positive approach as to how to approach your rent reviews. So what we're covering tonight is around rent reviews. We've got Adriana Vaux, who's one of our TFA advisors, who many of you, I'm sure, will know, and George Dunn, who's our Chief Executive, who I'm sure all of you will know. So we've got some real experts in the room to give us all some advice about how we should be approaching rent reviews. And I'm sure just at the moment, this is a particularly hot topic, given where we are with the reductions in BPS, the introduction of ELMS, perhaps the lack of detail we've got about ELMS, and what we're all thinking about what we might want to do going forward. So I think it's a particularly topical subject. Before we get cracking on the rent review stuff, we've also got Linda Davey, who many of you will know now. Linda's attended all of these, I think. Certainly Marshall Woodridge and GRP have, and as many of you will know, Linda heads up the relationship for our insurance partners between the TFA and GRP, and she's going to tell us the bad news. I think that our insurance premiums are all going to go up, but the good news about how we should manage that, and why that is, and also how we should manage it going forward. So that will be an interesting short session from Linda as well, I think. So welcome, as I say, to everybody. As we can see, this is, as I said, sorry, this is our fifth one of the winter. We do intend to keep these going through the spring and summer and however long it takes. Very pleased with the sign up we've had for these. It's interesting, and hopefully people are finding them valuable, interesting, and a good use of time. So as ever, I will try and keep to time. Can't always guarantee that. Very grateful as ever to Barclays, who have sponsored the winter series. We are, and this is the final one in their sponsorship run, and obviously we'll talk to them further about future sponsorship. But if anybody is interested in sponsoring webinars going forward, we are interested to talk. So by all means, get in touch with Julia if that's something that your business might be interested in doing going forward. So I think we're pretty much there. It's just about 7 o'clock. So we'll pretty much get started, I think. As I say, just to kick off this evening, we've got Linda Davey, part of the GRP Insurance Group, who's going to talk about the future trends for farm insurance. As I kind of perhaps I stole her thunder by telling you she was going to talk about the fact that our premiums are going to go up, but she's going to explain why that might be and how we can manage them. So over to you, Linda.
Thank you, Mark. Everyone hear me okay? Because I managed to have my volume turned down last time. Good evening, everybody. Linda Davey from Marshall Woodridge, part of the GRP group. And I am the bearer of pretty bad news, unfortunately, about your insurance premiums for the next possibly 3 to 4 years. We are heading into what they call a hard market, which we haven't seen in the insurance world for possibly nearly 20 years. After 9/11 happened in 2001, the insurance market tumbled rapidly into a hard market, which basically hard market means that there is less choice of insurers and higher premiums and more stringent requirements from the insurance company to get what you want. So it's not particularly good news from that point of view. And the reason why we're heading into a hard market this time round is a bit of a perfect storm, really. But there's not just one reason. It's not just COVID. It's not just one thing. Since 2016, this has been building up when the Solvency II regulations came in. Now, they are regulations that have been created by the regulators And they have said that in addition to every insurance company's liabilities, that they also obviously have to cover their liabilities to be able to trade, but they also have to have an additional surplus of assets and capital over and above their liabilities. Now, this came in 2016. Insurance companies have been struggling to free up their assets and have all the money that they need in this big slush fund, so that they can comply with the regulations. And so after all their spare capital was used up complying, the last thing they needed was a large claim hike. Cue the Ogden rate in 2017, which was a posh way of basically saying that awards in courts have gone up massively. So the Ministry of Justice moved the rate at which your claim is calculated if you have an injury. So in other words, employers' liability or public liability claims were calculated at a certain level. They moved that rate of calculation because they decided that the interest rates just weren't available anymore to invest your lump sum in. So that added millions of pounds overnight to insurance companies' claim reserves. On top of that, in 2020, we had storms Dennis and Kira, whopping great payment of around 425 million. Those storms are going to cost the insurance companies. And if you add into the mix investment losses, because the interest rate is so low that they can't invest all your premiums and get a return on those to keep your premiums down in future, they're making a worldwide loss at the minute. So they can't bolster their funds by investing and getting a decent return on those investments anymore. And then finally, if you add in the COVID-19 situation, which is going to cost about $4.3 billion just in the UK. And I know you're all going to say, well, nobody's covered for COVID. Nobody's got business interruption because of COVID. And that's true to a large extent. But where they have been paid, where there are valid claims, they are going to amount to millions. So the very few that are covered have really going to smash the budgets of the insurance companies. It's going to be the largest single claim paid ever. So this is rapidly producing a hard market where the insurance companies have no choice but to put the premiums up because their reserves are dwindling, and they can't trade if they don't put premiums up and recoup some of the monies that they paid out. And some insurance companies just haven't survived. In the last, if you look at Ireland, where the market has hardened already, 250 insurers have pulled out of the market, half of those in the last 2 years, which gives you much less choice about where you go for your insurance. So there's things you can do. So, I mean, in terms of budgeting, which is what you should be doing for the interest rate hike over the next 3 or 4 years, which is how long it could stay around, you should really be, it all depends on your claims history, etc., etc. But you could be budgeting for a 20 to 30% increase on your premiums. You can help with that situation by investing in risk management. So, work with your insurers, work with your broker, and try and make yourself the best you can be, which is more attractive to getting a better rate out of the insurance company. Work with someone knowledgeable, work with an insurer or a broker that's actually well-trained and knowledgeable, and they can turn a no into a yes if they have to. If you don't think your insurance advisor is knowledgeable enough on any of the issues, then plan your renewal, go to the market, find somebody that is going to work for you and get you the best deal out there, because there are still deals to be had. They're becoming few and far between, but they are there. And just beware of using offshore solutions because they're not properly regulated and they haven't got the solvency funds in place yet, which other UK insurers have. So just be aware of that. But just use, go to the market and early and do your insurance renewal in plenty of time, and go to someone who can look right through the market for you, not just one insurer, but go to lots of different marketplaces and try and get you a better deal than you might have been offered. So that's all I can say really on the subject. I could go on about it for hours, but I know I'll bore you to death. So and you've got better things to discuss with the rent reviews. So that's all from me, I think, Mark.
Thanks very much, Linda. That was actually really interesting to sort of understand the dynamics behind the market. And I think perhaps one of your bits of advice there about managing your risk and minimizing your exposure by making sure you're well covered in terms of sort of health and safety aspects and all the things that you should be doing on your farm is really good advice. So thank you very much for that. I should have said earlier that there's an opportunity to put questions to all of our speakers tonight at the end of the presentation. So if you would like to use the Q&A button, which is at the bottom of your screen, I think, certainly the bottom of my screen, in order to put the questions in, we will endeavour to collate those as we go this evening. And ones that we don't get around to, we will try and answer and post answers to on our website. So I guess one of the things that Linda's highlighted there is that our premium is going to go up. So that's another cost that's going up. So another reason why our rent should be coming down. We're going to hear first of all from Adriana about the sort of how we go about presenting the cover to trigger what covers start of it to trigger a rent review. Sorry, I'm twisting my words up there. What the basis for a rent review under the 86 and 95 Act legislation is, how we should deal with negotiation, what evidence we should gather, how we should reach agreement, and the process of arbitration and expert determination. Adriana has about 15 minutes to cover all of those topics in a huge amount of detail. So I won't carry on. I'll just let her go for it. So over to you, Adriana.
Thank you very much, Mark, and good evening, everyone. As you're probably very keen to find out, rent reviews are quite the hot topic at the moment. Although, having said that, they're actually quite quiet at the moment. Across my desk, I haven't seen very many rent reviews. A lot of landlords are choosing to not serve notices, and we're having a few members, tenants, serving notices, and then a few landlords who have decided to jump on the bandwagon and serve notices, but generally it's quite quiet at the moment. So this evening I'm going to be talking to you about the steps of a rent review and what's involved, and just information which you might find interesting in relation to how the rent should be properly calculated, because often we come across plenty of examples where figures are what seemingly pulled out of a hat. So firstly, how do you go about triggering a rent review? Well, under both an FBT and AHA, the Act states that it must be a minimum of a 3-year rent review cycle. However, FBTs slightly differ in that anything can be written into an FBT agreement other than an upward only rent review clause. So therefore, you need to check your tenancy very carefully for any rent review provision which is specific to your tenancy agreement. But if there isn't, then it will follow the minimum of a 3-year rent review cycle. So the next thing to look at is the rent review date. This is usually the anniversary of the tenancy or the date stated in the agreement. The party wishing to have power to have a rent review must serve an initial written notice on the other side under Section 10 for the Agricultural Tenancies Act 1995, which is an FBT, or under Section 12 of the Agricultural Holdings Act 1986, which is for an AHA. Any rent review under either Act must be served, so that any rent review notice under any Act must be served between 12 and 24 months ahead of the intended review date. So, for example, if your tenancy runs from the 29th of September, the rent review notice must be served on the other party by the 28th of September. You must also make sure that you allow plenty of time for the preparation of the notice, and it's particularly important that sometimes you can serve the notice incorrectly. So for example, if you have posted it but didn't send it recorded delivery, and the other party is saying they haven't received it. You want time to rectify that, so you actually serve the notice in good time. And these points are really important. So everything I'm saying this evening is valid for both a landlord and a tenant. So it's quite useful to see if your landlord's actually, what you can expect from the landlord's agent if they're the ones serving the rent review notice. So there isn't a prescribed form for a notice. We often get quite a few questions on this. But it should state that the rent properly payable in respect of the holding as from the review date be referred to arbitration in accordance with the Agricultural Tendencies Act or the Agricultural Holdings Act. Members will have access to a rent review notice for either AHAs or FBTs on our website, or you can contact us and we can email you one out. Delivery of notice is really important. It should be done by hand. And if you do this, you need to make sure that you obtain a receipt. And it's a good idea to get photographic evidence as well, or by post. And the best option for this is recorded or special delivery so that it can be tracked and traced. We often hear members wondering if they can send it by email. That's not allowed, so it has to be done by post or by hand. It's also a good idea for when you're thinking of serving a rent review notice to consider the economic conditions to see if it's the right time to review the rent. And sadly, this doesn't often happen when it comes to tenants being served rent review notices. So checking the economic climate, and obviously at the moment it's a very difficult climate. So that is why a lot of tenants are now thinking about serving notice on their landlords. Once a rent review notice has been served, it may only be withdrawn with the consent of both parties. So that's something to really bear in mind, which is why you need to be really sure and that you've calculated whether you should serve a rent review notice, because once you serve it, the landlord could jump on the bandwagon of that notice. So you need to make sure that you're happy with serving notice on the other party. If you have been served notice yourself from the landlord, then it's really important to check the validity of the notice. This is something that we TFA advisors can do for you. So you need to make sure that the notice conforms to the provisions of your tenancy agreement, such as the correct date and the correct acts being referred. And a rent review is not only a good opportunity for having the rent reviewed, but it's a chance to discuss other matters such as repairs, new investments, succession, or diversification with the other party. Now, the basis of rent reviews are very different between FBTs and AHAs. So I'm just going to flip to the next slide so you can see. But basically, FBT, in essence, is the sum of which the holding might reasonably be expected to be let on the open market by a willing landlord to a willing tenant, taking into account all relevant factors. And then you can see below that how an AHA rent should be calculated is the rent at which the holding might reasonably be expected to be let by a prudent and willing tenant to a prudent and willing landlord, from a prudent, willing and landlord to a prudent and willing tenant, taking into account all relevant factors, including the terms of the tenancy, the character and situation of the holding, productive capacity and its related earning capacity, and the current level of rents for comparable lettings. So if we break this down on the basis of rent reviews, reference to a landlord and tenant indicates that consideration is given to a hypothetical landlord and tenant rather than the actual landlord and tenant. So this means that the personal circumstances of the parties become irrelevant. The reasonable expectation of the rent level means that it's not the expectation of either of the actual parties to the review, but an external objective view from someone such as an arbitrator and what he or she could reasonably expect to be the outcome on the valuation date. Now, the valuation date is the review date for which the rent review notice is effective. And this takes into account the conditions of, for example, Section 13 of the Agricultural Tendencies Act. For an FBT, the open market is the benchmark for calculating a rent. It is therefore assumed for rent review purposes that the holding is let in an open market. This is one where there is no restrictions on who may bid and be accepted. Now, willing parties mean that the parties are both required to be willing, meaning that the rent determined is to reflect a properly competitive market rather than a very high one or a very low rent. All relevant factors are to be considered for with FBTs, and only the terms of the tenancy agreement have been expressly identified. So an arbitrator would look at all the evidence in front of them and give it such a weight as they feel appropriate. And for an AHA, we can see that there's a lot more to it. So there's more criteria which need to be adhered to. and they identify the terms of the tenancy requires consideration of any formal agreement, any memoranda, or any other documents varying the terms of the tenancy. And the character and situation of holding means that there should be full consideration of the physical nature of the holding. The productive capacity should be assessed by a physical assessment of the holding's potential for production in the hands of a competent tenant using a suitable farming system based on a view as to the stocking and cropping of this holding and measured in physical output. Then there's the related earning capacity. This can only be assessed once the productive capacity has been identified. It is the extent to which, in light of that productive capacity, a competent tenant practicing such a farming system could reasonably be expected to profit after rent from the holding. Often this is shown by way of a whole farm gross margin. And finally, comparables. This is evidence of the current level of rent for comparable lettings. So as you can see, there is a huge amount to take into account when calculating your rent. And as I said earlier, we see a lot of times when tenants are provided with a letter which basically says, this is the proposed rent, but there's absolutely no justification of how that's calculated. So those steps should have all been taken to calculate the rent, and it's definitely advantageous and beneficial that you see all the justification of how that rent has been calculated. So dealing with negotiations, so go back a slide. The party who initiated the rent review should have a clear timetable in their mind to allow enough time for resolution of any issues, so no party has to negotiate against a deadline. I hear far too often that tenants feel pressurised into agreeing a rent because the rent review date is, for example, next week or even the next day, and they've only just been contacted. It is not true that you have to be bullied in this way. Not only would this look bad practice on the other side at arbitration, but the rent review date is simply the date which, if the parties haven't agreed by that rent review date, the party who initiated the rent review has to apply at their own cost to the RICS for the appointment of an arbitrator to stop the rent review lapsing and to enable negotiations to continue. It does not mean that you're going to arbitration. This is simply standard practice to keep the rent review live, otherwise it extinguishes. And during negotiations, if you're provided with a rent review proposal, which looks like it's just been plucked out of the air, you are allowed to ask for thorough justification for that figure, whether this is budgetary and comparable evidence for AHAs or just comparable evidence for FBTs. Because, for example, you wouldn't agree to pay a fine if you had no idea what that figure was for. So why should you have to pay a rental figure if you have no idea how it was calculated or why that figure? So landlords' agents love putting the ball back in the tenants' court by trying to get them to provide evidence as to where they want their rent to be. Well, the onus of providing justification for your figure should be on the party who wants the rent review to happen. So don't get sucked into laying all of your cards on the table. Stand your ground and request the right information first. So you'll often see in correspondence terms such as without prejudice. This commonly is used within correspondence between parties, and it allows parties to explore possibilities for agreement without their offers being used against them as evidence in that dispute. And then you often see, for example, save as to costs. And this is used because at the conclusion of a hearing where costs are considered, the communication can be used to determine that issue. So don't be afraid when you see without prejudice, save as to costs within your correspondence. That's quite normal. You often have open correspondence, and that's when you don't have without prejudice or save as to cost on the letter. It's not hedged with anything, and this is known as open correspondence. And when you write to the other party on a not without prejudice basis, this means that your correspondence can be used as evidence at arbitration by either of the parties. I strongly advise members to read our TFA Guidance Note on rent reviews because they're really quick, easy guides to have at your fingertips, and they provide you with everything you need for tackling a rent review. If you want to obtain copies, then please do contact us at the TFA head office. So next you then go on to gathering evidence, which I think is the next slide. Evidence is very important as this is how you will argue your case. And also, should the matter go to arbitration, an arbitrator will determine the rent review on the basis of the evidence submitted to them. So the parties should prepare the presentation of their cases with everything needed to substantiate it. Examples of evidence are detailed comparables of similar holdings to your holding, whose rent is close to or the same as the rent you are hoping to achieve on your holding. The tenancy agreement, attributes of the holding, and budgetary evidence if you're on an AHA. So reaching an agreement. Once you have reached an agreement, if an arbitrator has been appointed, they will need to be written to so they can stand down. The tenancy terms relating to rent and any other matters agreed should be recorded in a formal memorandum signed by both parties and kept with the rest of the documentation relating to your tenancy. Just go to the next slide. So if you cannot reach an agreement, then you have to resort to dispute resolution. And this is firstly, the most common one known is arbitration. So the party who wishes for the rent review to continue past the rent review date writes to the RSCS by the rent review date for the appointment of an arbitrator using a DRS3 form and at a cost of around £115. And that should be paid by the person who wants to initiate the rent review. And it's sensible for the parties to jointly agree via a form called DRS5 to serve on the arbitrator to put them on hold whilst negotiations carry on. And this will simply put the arbitrator on hold and stops all the costs from adding up. An arbitrator will usually suggest having a preliminary meeting to discuss procedure, timetable, fees and costs. And this is an important meeting worth having. An arbitration hearing can be done by written representation, which tends to be slightly cheaper, or a full-blown hearing. The parties seeking the review will first submit the arguments for it, and then other parties will respond to that submission and cross-examine the evidence. For a hearing, the arbitrator will ask parties to agree and submit a bundle of documents, fully referenced and indexed so that he can or she can easily go through these. Witnesses are likely to be required for a hearing too, and they'll be cross-examined. An inspection of the holding will take place by the arbitrator. And once written representations in a hearing, if there is one, is complete, an arbitrator will make the award. Now, it is in the power of the arbitrator to make an award not only as to who should pay his costs, but also as to the allocation of the party's costs, e.g. the losing party paying all costs. Costs likely to be incurred during arbitration are, for example, the arbitrator's fees and expenses, the cost of arbitrator's appointment, cost of parties in pursuing arbitration, any costs of action to determine the proper amount of costs. So as you can understand, an arbitration is incredibly expensive, but there are ways and means of protecting yourself against costs. Firstly, by having legal protection insurance in place, such as our TFA legal protection insurance, which helps pay for disputes. And then secondly, capping costs or making a callback offer, which George will go into later in this webinar. Now, there's also expert determination, which is an alternative to arbitration, and it's becoming, it's quite new and it's becoming, we think will be becoming more popular. So expert determination is a form of third-party determination, so I can carry on to the next slide, undertaken by an individual who has specialist knowledge and experience that enable them to make the determination. Experts take into account their own knowledge and research, unlike an arbitrator who is bound by the evidence provided by the parties. So the procedure for expert determination must always be agreed between the parties, and this process is often less formal than arbitration and supposedly cheaper. But expert determination is not obligatory unless it is written into an AHA or FBT. Otherwise, it requires the consent of both parties to follow this route. Now, how did expert determination come about? Well, the Deregulation Act of 2015 first introduced third-party determination, usually referred to as expert determination, as an alternative to arbitration in respect of a number of disputes which arise. However, it did not adequately cover the situation for rent reviews, which has now been corrected by the Agricultural Act 2020. Now, how does this work with rent reviews? Well, instead of serving a notice requiring the rent to be determined by arbitration, you now serve a notice requiring determination of the rent, which can then be settled by arbitration or by expert determination if it cannot be agreed between the parties. Expert determination does not follow a legislative code as an arbitration does, so it is absolutely vital that the parties to the rent review give the expert thorough instructions. Next slide. So I just wanted to, I'm sorry that was such a lot of information to take in, but we will have a copy of these slides available for anyone who wants the information. And I just want to say a huge thank you for listening, and please feel free to ask any questions, not just now and today, but afterwards at any point. Please do use your membership, as advisors are here at the end of the phone for any emails or questions, concerns, or if you want to look over any documents which you've received and you may not understand them, or you just want a second opinion, or you even want to know if they're okay to sign. We do advise on rent reviews daily. We understand that they're incredibly stressful. So it is really important to be one step ahead, always being prepared. Seeking advice is incredibly important, and getting all your ducks in a row. So as I said, having legal protection insurance in place is really important as a safety net in case both parties cannot agree. So thank you for listening, and I hope you found this helpful.
Wow, Adriana, that was fantastic. That was so good. A lot of information in there to cover. Brilliantly presented. I think maybe the slides were not quite as slick as Chris Whitty, but everything else was slicker. So well done. That was a fantastic effort. As Adriana said, please put any questions that you might have into the Q&A. We've had some that a few of you have sent us through earlier, which we will try and raise after George's presentation. But as Adriana said, please, remember the office is there. We've got some real expertise to help you through this process. It's never straightforward, but it's an important part of running your business. So we'll move on swiftly to George Dunn, who obviously many of you know as our Chief Executive. George is going to cover why it's important to take the initiative in serving a notice, the budgets and comparables, the treatment of the farmhouse, marriage value, what happens at the time, the use of call to bank offers, and understanding open market rent. So rather like Adriana, a whistle-stop tour, but he's only got 10 minutes to go and Adriana had 15. So you'll have to talk even quicker, George, but over to you.
Mark, thank you so much, and Adriana, thank you for so eloquently setting the scene. What I want to do in my 10 minutes is to highlight what I'm going to call the 7 deadly sins. So this is about tactics that are quite often used against you or quite often used in rent reviews that we just need to unpick a little bit. And the first one that Mark referred to is the issue of notice. Obviously, no notice, no rent review. If there's no notice served, there is no formal rent review. And sometimes we find landlords who will say, well, no one else has served a notice. Why have you served the notice? Don't be embarrassed by the fact that you may be the only one on your estate serving a notice. You might just be at the front of the queue and causing a bit of a wave of notices coming through. But we would much rather be in a position with this year particularly to see a whole lot of notices being served, because that will engender a feeling within the rental market that things need to change. So there is absolutely strength in numbers. So the more people who can serve notice, the better. We don't really see landlords having much of an appetite to serve rent review notices this year. So it really is going to be down to us to be at the forefront of getting rents down as far as we possibly can. Secondly, the issue of farmhouses, the vexed issue of farmhouses. And this is an area where there has been a considerable amount of dispute between landlords and tenants down the years. So I've heard tenants say, well, I've got to live in the farmhouse, therefore, surely I shouldn't have to pay additional rent for it. That's not true. And landlords will say, well, surely we should be able to take into consideration the value of farmhouses being let on assured short-hold tenancies. That's not true either. The issue is you've got to be comparing like with like. And we've got a guidance note, which is actually publicly available because we wanted to be helpful to the marketplace as a whole, which sets out how you properly deal with farmhouses within the context of a rent review. And obviously the repairing obligations on a rent review, on a tenancy let under the agricultural legislation are very different to those within the housing legislation. and what you can do with a house is also very different. So you've got to be comparing like with like. Do not try to see a situation where the landlord forces you into a position of agreeing a rent for the farm and then arbitrarily slapping a value for the farmhouse on top of that. That is not the way to do a rent review, and you must guard against it and take advice from us if you find that tactic being used against you. The third area that we quite often hear raised, particularly in the context of AHA tenancies, and Adriana gave you the criteria against which rents are reviewed on AHA tenancies, we quite often hear landlords saying comparables are more important than budgets. And that tends to be the case when the economic marketplace within which agriculture is operating is on a downturn, because obviously the rent is a lagged index and rents will fall after you see a fall in the economic output of agriculture, and landlords then tend to look at comparables as the evidence that they want to rely upon. The truth is that, as Adriana has said, comparables are just one component of the four components within which an AHA rent review has to be reviewed: the terms of the tenancy, the character and situation of the holding, the productive and related earning capacity, and the rents being paid on comparable units. Of course, all other relevant factors are in there too, but don't be fooled by a landlord who suggests to you that it's the comparable evidence in an AHA rent review that's the most important. It's not. It must be balanced against the other things. Within farm business tenancies, though, we are on much more difficult ground when it comes to comparables, because, as Adriana has said, the basis for agreeing a rent on an FBT is the basis of the open market. And we have had some case law. It's Scottish case law, but it also has relevance in England and Wales to tell us what open market means in the context of an FBT rent review. And what the case law suggests is that there's a pyramid approach to the evidence that is presented. So the best evidence in the open market is the evidence of individuals who do transactions or make agreements for the first time for land occupation. So you might call those tender rents. So the court sees that as the pinnacle of the evidence for open market. However, the second order is rents being paid by people who are already within relationships and are doing rents at review. So if there's not much evidence of open market lettings, then this wider body of evidence can be brought into play. And this is quite important from our perspective, because if you look at the DEFRA rent figures, you'll see that the average level of rent on FBTs is a considerable amount below the sorts of tender rents that we quite often get quoted. And the tender market is quite narrow, but obviously there are plenty of people out there who are doing deals on a day-to-day basis at rents far, far below the level of rents being tendered by some people in the marketplace. So we believe that evidence is really quite important. And then the third order, if there's no open market and no reviewed rents, then you go to budgetary evidence. But we think that body of evidence that's in the DEFRA survey is quite important in that respect. So then we come to the issue of comparables themselves, and I know Andrew Harrison's asked a question about that in the Q&A. And what I'd say is there are lies, damn lies, and comparables. And you need to be really careful when you are being faced with a landlord who has proposed a comparable. And just because they say, well, you know, Joe up the road has been willing to settle at a rent of £100 per acre, why don't you want to settle at what I'm suggesting to you is a very sensible £95 per acre? Unless you really know the holding, unless you really know the fact that Joe has settled at £100 per acre, it's not a proper comparable. You need to be able to make sure that it's like for like, that you're able to take out those elements which are similar to your holding or not similar to your holding. You need to look and see if there's any skeletons in the cupboard that the other tenant has had to settle at a rent higher than they would otherwise have done. So make sure you get the opportunity to get the full detail. The fifth area I want to highlight is called latent value. And this is something which we're seeing time and time again, landlord suggestions. This is where a tenant has invested in fixed equipment on the holding, and ordinarily the value of that investment in a rent review would be excluded. But what landlords quite often say is, oh no, well, there's latent value. And what latent value is if there's something special about the holding that they are providing to you, that your investment has unlocked more than it would otherwise have done in another circumstance, then they're entitled to that rent. Let me explain it in this way. If you had a holiday cottage on the Cornish coast, you might expect to do better with that holiday cottage than if it was within Grunty Fen, where not many people would want to go for a weekend retreat or a holiday. And because the holding is in a better place, from perspective of the market, your investment might therefore produce a greater return, which the landlord is entitled to. But for standard things like poultry sheds, beef units, dairy units, etc., none of that actually produces latent value. So beware of landlords bringing ideas of latent value. Sixthly, there's the mantra of marriage value. So landlords quite often say, well, your holding would ordinarily be attached to another holding, and therefore you've got to pay a bit more because of marriage value. And landlords are entitled to obtain marriage value, but what sometimes you find is that a landlord will quote a rent for a comparable holding and say, well, the rent is £100 per acre on that holding. Therefore, if we bring in marriage value, that might bring it to £125 per acre. Well, actually, that comparable holding is already pregnant with the marriage value that the landlord is trying to address. And the legislation says that when you look at that as a comparable, you've got to strip out the marriage value when you compare it with your own holding. So again, beware when the landlord refers to marriage value, and always take advice. And my last deadly sin in relation to AHA reviews, particularly, is where landlords try to claim that FBT rents are comparable with AHA tenancy rents. They are not. They are absolutely not. And you should always ensure that you argue against situations where the landlord is trying to bring FBT comparables into the rent review discussion with you. So those are just some of the tactics that you need to be aware of in terms of the conduct of a rent review. And finally, just before I hand back to Mark to chair the Q&A session, we talked about call-to banks. Call-to banks are a really powerful device to assist in rent review negotiations, particularly where an arbitrator or an expert has been appointed. But what the call-to bank offer says is, okay, I'm asking for a rent of X, but on a without prejudice basis, save us to costs, I would be prepared to agree a rent of Y. So as a tenant, you might be saying, well, I want a rent on an AHA tenancy of £50 per acre, and that's your opening gambit. But actually, on a without prejudice, save us the costs basis, you would be prepared to accept the rent at £60 per acre. So if the arbitrator then decides to set the rent at £55 per acre, then you can show your comparable, show your call-to bank offer to the arbitrator, and the arbitrator will say to the landlord, you would have done better accepting the tenant's call-to bank than bothering me to set the rent at £55 per acre. So all of the costs of the arbitration goes against the landlord in those cases. So call-to bank offers are really powerful opportunities to put pressure on the other side to settle at a figure, because costs can be quite enormous for some of these reviews. So Mark, I've got 1 minute over my time. I do apologise. I hope that's been helpful in terms of some of the tactics, and obviously we'll answer any questions that arise from the Q&A.
Great. Thanks very much, George. As with Adriana, another excellent sort of run through of what is really quite a complex area, and but it's really important to us. And I do feel at the moment in the current climate, with all the changes that are going on, creates both opportunity and challenges, but certainly should be making us all just look at that rent figure and see what we should be doing. So really useful to have that input. So we've got a few questions that are coming through on the Q&A. We've had some questions that were sent in prior to the prior to this evening's webinar. So I'm going to probably do a little bit ham-fistedly, but I'm going to do my best to pull some of the questions together and ask Adriana and George to chip in and answer the questions as best they can. And don't forget, Linda's here as well if you've got any insurance questions. So I'll just kick off with something that I'm just trying to, James Seller has raised in the chat about rent review notices being served earlier than in the past, and also just considering where we are with Elms, the lack of detail around Elms, and what we know about BPS and the gradual reduction in it. When do you consider, George, I might throw this to you first, is a sort of right time to be looking at serving a notice in the current climate?
Okay, so what we know already, Mark, is that the basic payment scheme payment will be reduced within 3 years for everybody by around half. And I think that should all make us sit up and think about what that means for our farm businesses going forward. And obviously this year, a lot of sectors have done better than they would have expected in terms of the sheep sector, the beef sector, cereals prices, milk, although we had a dodgy start to the year, has finished the year relatively strongly. Obviously, we've got problems in pigs and potatoes at the moment and other of those types of sectors. And what I would say to people is don't necessarily accept that that's a permanent change in the marketplace. And the rent review provision is there to provide an opportunity to regulate the rent according to the current market conditions, but you've got to do it at least a year in advance. So I would certainly be encouraging people to have the option of a rent review, because we really don't know what the coming year is going to hold for us. And we're setting the rents now for the next 3 to 4 years. So I would be certainly encouraging people to put their hat in the ring for a rent review. If the market massively improves to the extent that we're all making more profits, then a little bit more rent may be payable if you effect a rent review. But I think things are just so uncertain at the moment, and with the BPS coming down so sharply, we don't yet know what's going to replace it in terms of Elm. I think there is a real opportunity here to put something in place. I see James also refers to the insurance side in his question, and it's really important that people take out the insurance either before they serve or receive a rent review notice. They cannot take out the insurance for that particular rent review if they've taken it out after the notice has been served.
Thank you, George. So we ought to be getting our pens out and sending the letters off and following Adriana's advice to get our notice in sooner, and your advice to take the initiative. So food for thought there. Just moving on a little bit, Adriana, perhaps I could fire this one at you. Mark Peters in Sussex asks, how would you approach an FBT rent review when you know that the comparison in your area is actually a lower rent that your rent is currently lower than what might be comparable in the area, and in that circumstance, is it even worth doing?
Yeah, that's a good question. Obviously, it's the terms of the tenancy which need to be taken into account too. But with FBTs, it is difficult because comparable evidence is the primary source. I think it really comes down to if you know that the landlord's agent is going to be able to obtain comparables that show that the rent is higher for comparable holdings around your area, and if you can't provide comparables to show that the rent should be where you want it to be, you are in a bit of a sticky water, I'm afraid. So if you don't have the evidence to justify the rent which you need, I think it probably would be worth laying low.
Okay, thank you.
Mark, can I just interject there? I think this is a really important point that we all need to get our heads around. Just what I think we need to realize is that the deal that individuals do with their landlord is not a private deal that just impacts them. It impacts everybody else. So you might decide, well, I want to pay over the odds for this farm because it makes sense for me. Well, you are actually doing a disservice to every other tenant in the area, because that rent that you are paying will be used against other tenants in the neighborhood for the rent reviews, and landlords agents will use that as a ratchet to push rents up. So I think there's a clear message that we need to put out to everybody who's bidding on land to be prudent, to be sensible, and to realize that your rent is not just a private matter between you and the landlord, that it can be used against another tenant for a rent increase. But equally, as Adriana was saying, the terms of the tenancy and the nature of your holding could mean that the rent that your neighbor is paying is right for his farm or her farm, but it's completely wrong for yours for varying reasons. You might have a wetter farm, you might not have a good range of buildings, or you might suffer more from issues around public access, or there might be greater pressure from sporting interests. So just because someone is paying a higher rent doesn't automatically mean you need to hang up your hat and say, well, that's tough on me. Do a little bit of homework, find out what the differences are, and see whether you can still pursue it. But I would say again, everybody needs to play their part and remember that your rent is possibly being used against your neighbour.
That's a very good point, George. Just following on from that, in terms of rent levels, Stephen Bumstead asks, is the gap narrowing between AHA and FBTs? I don't know who wants to pick that up.
I don't think we're seeing anything like the sort of narrowing that we should be seeing. I mean, obviously, FBT rents tend to be a bit more volatile because they are open market and based on what's happening at the time. AHA rents are always lagging behind the market because they have to look at budgets in a historical way. So I don't think there is any real evidence to suggest that the gap between the two is ostensibly reducing over time. I think there is still a pretty large gap.
Okay. Adriana, perhaps you might like to pick up. I'm going to throw a couple of you here that have been sent in. One from Stephen Caddow in Northumberland. I hope I pronounced your surname, Simon. I pronounced your Christian name wrong because I called you Stephen. So that's not a great start. Simon Caddow. I hope I pronounced your surname right. It says, when negotiating a rent review, can a lack of maintenance on buildings which are the landlord's responsibility be used as an argument for reducing the rent?
Yeah, this is definitely a really relevant factor. And in fact, it was only recently that I had a letter from Savills to say that because they're having to carry out works, which I may add were their obligation, they feel that they have to increase the rent because it has to reflect the work they're doing. So you can switch that around, obviously. I mean, that's wrong. It's their obligation. So you shouldn't do that. But if the buildings are not in a good state and they haven't been, no work's been carried out and the landlord's refusing to do it, then that is a relevant factor in a rent review, that the buildings aren't fit for purpose, or they need work and they haven't been done. So yes, it should be taken into account and would affect the rent that should be payable.
Okay, thank you. Andrew Carter asks on the chat here, which perhaps goes back to one of the earlier questions, that the agent insisted at his last review that rent reflected what was current and not what was in the future. So on that basis, can we build in the future reduction of single farm payment, basic payment?
Mark, I think that the landlord's agent was completely wrong in that respect. Yeah. Because what the rent review provisions of both pieces of legislation try to do is to suggest what would in the case of the AHA tenant, the prudent and willing tenant pay for a holding if they were looking at that farm over the next 3 years. And the FBT tenant just has to be willing, not necessarily prudent. We would argue that they should be prudent, but and looking ahead at what they would offer. So you're always looking ahead at what the farm's going to deliver for you and paying the rent in accordance with what you're expecting to obtain in terms of the return from that holding. So it's completely wrong to say that the rent should only be agreed on the current situation. You really got to look ahead at what that holding can produce for you.
Yeah, no, that's right. I thought it was useful to just make that point, particularly as Adriana made the point in her presentation, I think, about looking at the economic climate. And one thing that we do have in regard to BPS, which we don't often have when we're talking about rents and what the future is going to hold, is that we do know for certain that BPS is going to go down, whereas we don't know what the wheat or milk price or whatever might be. So it's an interesting time to be negotiating, I think, or looking at rents. Another one, perhaps, George, for you, if you don't mind, which is specifically on dairy. Jeffrey Sayers from Plymouth asks, what do you think the effect of BPS reduction on payments, specifically with dairy in mind and dairy units, will be on the rent levels, and what should we be looking at in that respect?
Well, I mean, obviously the dairy farms were the ones that started out with a relatively low level of a single payment when we started this process, and have built up to the average level. So they will be in exactly the same boat as every other farm type in terms of the area of the holding being able to attract that 80 quid per acre on the BPS if you've got those entitlements. So in terms of the impact of the loss of BPS across farm types, including dairy, you are going to lose half of those payments by 2024 at least. And we know that there's a real difference in the marketplace in the dairy sector for those who are on co-op contracts and those who are on aligned contracts and those who are on non-aligned. And we still see, effectively the milk is, if I can use a pejorative term, stolen almost by some of our from some of our members who are on non-aligned contracts. And we have the government thoughts about the new code of conduct that's going to be on a statutory basis, which might improve that for some of those non-aligned individuals. So I think it's very difficult to generalize for dairy farms as a whole, but I do think that particularly for those dairy farms who are on non-aligned contracts, losing BPS the next few years is going to be relatively tough, and therefore likely that rent reductions could be in the offing.
Okay, thank you. I'm very conscious of time, and I'm also very conscious about the huge amount of questions we've got. So just before I ask the last couple of questions, just to confirm that we will be putting the answers to a lot of these questions onto the website. Reminder that the whole of the webinar, both the presentations and Linda's presentation, are available on our YouTube channel and will be available on our website if you want to go back and look and hear what's been said. So I'll just come to a couple of questions. There's one for either one of you two and one connected for Linda to finish us off this evening. Paul Crawley asks, how can we value diversification income, and are there comparable rates for them, and how does that play out in a rent review? And just so that Linda can prepare herself, Ian Cairns also asks that they also have a farm diversification. They hold special insurance for that. Should he be expecting that insurance cover will also be increasing significantly?
Shall I go first, Mark, on the diversification income, and Adriana can pick up anything that I've got wrong or forgotten. Quite often the diversification on a holding is as a result of the tenant's investment. So the first thing that I think you need to do is to make sure that you are valuing out the impact of the tenant's own investment in that diversification activity. Secondly, a lot of diversification is quite bespoke to tenants because they're good at the diversification that they have put in place. And again, you shouldn't necessarily have to pay more rent because you're good at a particular diversification. So there is that to factor in as well. But obviously, if the holding that you are operating provides you with a good opportunity to do the diversification that you're interested in, then quite clearly it's fair that the landlord should take a return from that. And even more fair if the landlord is prepared to invest in some of the buildings or the fixed equipment necessary for you to conduct that diversification. So, for example, it might be about providing an opportunity for milk processing or meat processing. And if the landlord is prepared to assist in investing in white room facilities or in some sort of dairy facilities, then of course the landlord should get a benefit from that. But you need to be really sure of where the benefit has come from and how that investment has come around.
Right, thank you, George. Do you want to add anything, Adriana? Do you think George got that right?
Yeah, no, George covered that well.
Linda, did you want to just finish off on the should we expect our diversification insurance to go up also query?
Yeah, the answer in a very short sentence is yes, I do expect it to go up. Last time there was a hard market, it was a fairly broad sweep right across the entire insurance market that prices went up. It's not just one sector or another, or just one insurer or another. It's I anticipate diversification possibly going up more than the farm insurance. It's quite a specialist market to get the right cover for diversifications, and it may be those sorts of diversifications that insurance companies choose to tighten up on more than the general farm insurance. So I would be particularly wary about cost increasing for that.
Okay, thank you. On that bright note,
Sorry.
well, I'm very conscious of time, and I mean, we could go on literally, I think, all evening on this with the questions we've had previously sent in and the ones that are coming through on the chat. So I will just first of all apologise that we haven't been able to get through all of the questions. I'll reiterate that we will answer these questions. Some of them may be quite specific, so we'll come back to you directly. I'm making all sorts of promises for head office here, which I'm not going to get involved in doing any of this coming back or putting anything on a website or whatever. So I'm ensuring that head office will do all this for you, but I'm sure they will. And so we will endeavour to answer questions. We'll put up the answers as best we can to them. I notice that there's a bit of a theme come through latterly about landlords' approval for getting into new schemes or mid-tier and stuff. They're very relevant, and we don't have time to cover that now, but we will definitely be answering that because there have been one or two changes around that, and it's important that we know exactly where we stand as we go forward into ELMS. So just suffice to say, a big thank you to all of our speakers this evening, to Linda, to Adriana, and to George. Covered a huge amount of ground in a very short space of time. Lots of food for thought. So thank you all very much. And to remind people that we're continuing with this run of webinars. The next one is on the 24th of March, which is a Wednesday, I think. And we're covering farm tenancies, biodiversity net gain, and carbon credits. And I think that will be every bit as interesting as we head into the sort of new arena that we're heading towards as the previous ones and as tonight's has been, which I hope you'll agree with me, has been very good. So a big thank you to Barclays again for their sponsorship of the winter session of webinars. Really helpful. We really appreciate they're big supporters of the TFA, and we thank them very much for their continued support. And I hope you all have a very good evening and you've found the evening useful for you. And we'll hope to see you on the 24th of March. Thank you very much.